Welcome back, everyone, to the Banks Law Podcast. My name is Sonny Banks. I'm the owner of Banks Law. And as always, our goal is to educate injured workers in the state of Pennsylvania. If you're injured in the state of Pennsylvania at work, one of the first things you need to do is to give notice of the work injury to your employer. The law requires that you give your employer notice within 120 days of the injury. But in order to preserve your right to benefits from the first day of your disability, you need to give notice within the first 21 days. So let me give you an example. Let's assume that you wait and you don't give notice until the 90th day after your injury. Well, if you're awarded benefits, then the benefits are not going to start until the 90th day. But if you give notice within the first 21 days, then you're entitled to benefits from the first day of your disability. When giving notice of a work injury in the state of Pennsylvania, you need to give notice to a supervisor, someone in a supervisory capacity. You can't just give notice to a coworker or someone on your level. Notice must be given to a supervisor, should be your immediate supervisor. If not, then somebody in safety or HR, human resources. Yeah, let's take it from the point where you give your employer notice of your injury. Your employer then is required to give you a list of company or panel doctors to treat with, and also have you sign what's called a 90-day injured worker bill of rights, advising you that you're required to treat with the company or panel doctor for the first 90 days. You'd be surprised, most employers don't have a panel list. Most employers don't know what a 90-day injured worker bill of rights is. They're required to do both of those things. If they do one and not the other, then they haven't satisfied their requirement. And if they don't satisfy that requirement of giving you the panel list and giving you the 90-day injured worker bill of rights, then you're not required to treat with the company doctor ever. You can immediately start treating with your own doctor, which is obviously beneficial. Yeah, I mean, if they're provided with the 90-day panel list and they're given the 90-day injured worker bill of rights, they should sign it and they should, see the company doctor. What will likely happen is the company doctor will see them a couple of times and then discharge them. And at that point, they're free to treat with their own doctor. You should always try to get legal representation as soon as possible, even if your claim was accepted and you're receiving wage loss benefits, because at some point the insurance company is going to take steps to try and stop your benefits, to end your claim. And you're going to want to do things in advance of that happening so that you're prepared to defend against their attempt to stop your benefits. No, workers' compensation attorneys operate just like any other personal injury lawyer, meaning that our fee is contingent on the recovery that we get you. If we don't get you any recovery, then you don't owe us a fee. So the contingency fee applies. If you come to my office and you're already receiving wage loss benefits, then my fee doesn't start until litigation starts or the case settles. In terms of getting the proper medical treatment after a work injury, obviously, if the employer gives you a panel list and has you sign that 90-day notice, you are required to treat with their doctor for the first 90 days or until you're discharged. Once you're discharged, you have the right to treat with your own doctor. When you're at the point where you can see your own doctor, you should follow up with the lawyer and have that lawyer refer you to a doctor, because the lawyer is going to have a stable of doctors that are skilled, and they can treat the various work injuries. They're used to dealing with the litigation process, and they can take the steps necessary to make sure that your claim is processed appropriately. In terms of getting follow-up treatment for work injury, again, if the employer gives you a panel list and they have you sign that 90-day notice, you are required to treat with their doctor for the first 90 days or until you're discharged. Once you're discharged, you can treat with whatever doctor you want to. If you're at the point where you can treat with your own doctor, you should follow up with an attorney. because most attorneys, have a list of doctors that are familiar with the workers' compensation process, are good physicians who can treat you appropriately and make sure that your rights are protected. Yeah, that question is asked quite a bit. It's up to the injured worker to file a review petition to add injuries that were not initially accepted by the employer or the insurance carrier. The way to do that is to see an attorney, have an attorney file a review petition, make the allegations in the review petition that the accepting document didn't include all of the injuries sustained in the work accident, and then present evidence to the judge establishing that the additional injuries alleged in the review petition should have been accepted in the first place. Actually, theoretically, you can be on workers' compensation benefits for the rest of your life if you're able to prove that your injury hasn't resolved, or you're not recovered from your injury and you're still unable to work. But at some point, the insurance company is going to take steps to send you to what's called an independent medical examination. It's really not independent, it's a defense medical examination. That doctor will evaluate you for 5 or 10 minutes and issue a report saying that you're recovered. That gives the insurance company a basis to file a termination, suspension, or modification petition, either alleging that you're fully recovered and your wage loss benefits, as well as medical, should stop, or that you're recovered enough to be able to return to work in some capacity and that your wage loss benefits should stop or be reduced. We like to use the opinion of the treating doctor to combat the insurance company's attempt to stop or reduce benefits by way of a termination, suspension, or modification petition. There's no better opinion than the treating physician who's actually seen the injured worker over an extended period of time, who's able to accurately diagnose the injured worker, to adjust the injured worker's treatment based on their response to treatment, and to assess their disability because of the injury. The most important thing that an injured worker can do during the litigation process is be compliant with treatment. It's the old adage, if you're not seeing a doctor on a regular basis, then the injury must not be that serious. So the most important thing that an injured worker can do, while they're waiting for a judge to make a decision in their case, is to be compliant with treatment. And quite frankly, that should be the case even if their claim is accepted and they're receiving benefits. Treatment really is the key. That's the only way that you can defend against a future petition filed by the insurance company to stop compensation. Yeah, a psychiatric injury can be added to a claim. It's not easy. Insurance companies will fight adding a psychiatric injury tooth and nail because it's so subjective. It's difficult to establish that the psychiatric injury isn't present and that it's not related to the physical work injury. But the short answer to the question is yes, the psychiatric injury can be added, though it's not easy. It's always important to get anything in writing regarding your disability, whether the doctor feels you're totally disabled or that you can work but with restrictions. Especially when the doctor feels you can work with restrictions, you should really get those specific restrictions in writing, present those restrictions to your employer, and give your employer an opportunity to offer you work within those restrictions. Most employers won't be able to do that because they don't have light work, they don't have a sit down or a sedentary job, but you should at least give the employer an opportunity to try and accommodate your work restrictions. Absolutely. The goal here is to get injured workers back to work so they can, start earning the income that they made before the work injury. Remember, comp only pays out at 66 2/3 of your gross weekly pay, and sometimes, you actually earn a lot less than what you made before the injury. Granted, workers' compensation isn't taxed, but generally you earn less on comp than you do before your injury. So the goal is to get an injured worker back to work. If you get restrictions from your doctor and the employer offers you a job that is quote unquote within those restrictions, give the job a try. We always recommend that our clients go back, try a light job. If the job is truly light and you're able to continue doing it, you're going to be happy because you're going to start earning the same pay again that you did before the injury. And obviously the employer is going to be happy because their liability is reduced in the workers' compensation case. Yeah, if you actually go back to work to a light job and that light job pays less than what you made before your injury, then you're entitled to 66 2/3 of the difference. So let me give you an example. Let's assume you made $1,000 per week gross pay before your injury. You go back to a light job and you're only earning $500 per week. Well, you're entitled to the $500 per week in salary from the light job, and you're also entitled to 66 2/3 of the $500 difference. Absolutely. An undocumented worker, just like any other worker in Pennsylvania, is entitled to workers' compensation benefits. Again, you have to be an employee of an employer to be entitled to benefits in the first place. The only time that the immigration status becomes an issue is when the employer takes steps to stop or limit the claim by, proving that there is work available to the undocumented individual, but they're not able to offer that work because of their immigration status. In that circumstance, an undocumented individual's workers' compensation claim can be limited or stopped. And it's a bit different when you don't have an immigration issue. If there is no immigration issue, then the employer actually has to actually prove that there is work available either with the employer or in the general labor market before they can stop compensation. Yeah, I mean, the injured worker should not have direct contact with the insurance company at all, whether it's about settlement, treatment, or any other issue, especially where it pertains to settlement. Insurance companies are in the business of collecting premiums, not paying out benefits. They're in the business of saving money, not giving out large sums of cash to injured workers. So you can bet that any offer you receive directly from the insurance company is going to be a lot less than what the case is actually worth. Probably my father. My father worked in human resources for over 30 years. And I saw, some of the issues that he dealt with and, how he tried to protect employees' rights, even though he was in HR and his directions came from the employer. But I think he understood that there needs to be, a good relationship between workers and management in order to, run a smooth business. And he was successful, and I saw his efforts. And when I got the opportunity to get in the area of workers' compensation, I jumped at it. I think in terms of me landing in Philadelphia, that was just by, happenstance or coincidence. I went to Villanova Law School. After graduation, got a job with the city of Philadelphia. Started out in their civil litigation unit, defending city employees like police officers, firemen, against civil suits. And then they needed somebody in their workers' compensation department. So I jumped over there and loved it. And then ran into a claimant or plaintiff workers' compensation law firm that asked me to join them. And I was with them for a couple of decades. Yeah, I mean, unions are a big part of workers' compensation, and individual union rights through collective bargaining agreements are oftentimes highlighted or dealt with in the litigation of a Pennsylvania workers' compensation claim. We appreciate our union workers and what they do for the system and for businesses in general in the city.